Number 126, Alliance to End Chickens as Kaporos versus New York City Police Department. Thank you, Joe.
Good morning, Your Honors.
Good morning. Good afternoon.
Good afternoon. I'm sorry. A little nervous. I've never been in this court before, and someone told me that the room was intimidating, and it's true. It's true. But I'm very happy to be here. I'm Nora Constance Marino for the appellants and the petitioners herein. Your Honors, this case is about
Marino, before you start, would
Yes,
you
ma'am.
like to reserve any rebuttal time?
Yes, please. Thank you. 3 minutes.
3 minutes?
Yes, please.
Fine.
Okay. This case is about the executive branch of government ignoring a clear and unambiguous mandate.
Counsel, I'm sorry. You can see from the appellate division's majority citations that courts are generally hesitant to wade in a mandamus on enforcement investigative issues for a number of reasons. And I think one of the primary reasons seems to me is, what would you have the court do here? What would your relief be?
The relief would be a writ of judicial mandamus telling the NYPD that they must enforce the animal cruelty statute and the New York City Department of Health
What would enforce mean, though? So what would
An order.
enforce mean in terms of that order? Because if we're going to issue a writ or an order, there would have to be a way that whoever we issue it to could see how they would comply with it. So in any case, in an enforcement context, if we're mandamusing enforcement, what does that mean? Does it mean they have to respond to a report? Does it mean they have to make an arrest? Does it mean they have to pull resources off of a different type of crime and put them onto these types of crimes?
Your Honor, I'm glad you brought that up. First of all, this court issued that writ in Klosterman in 1987. You issued that writ regarding a case involving the health and hygiene laws where 2 psychiatric patients were released, and they ended up being homeless, and there is a law in the mental hygiene law that requires the state to take care of them and follow up. And they sued. It went up to this court, and this court said to the state, yes, this is a mandatory law. It includes the words must or shall. It's a mandatory law. And the state actually even put in opposition in that case, including affidavits, saying we would love to help them, but we don't have the money. And even with that affidavit, this Court of Appeals still said that's not an excuse.
We issue the order that you're asking for enforcement, and there's a call reporting an alleged violation of one of the statutes that you reference. What then is the response that needs to happen under our order?
The NYPD and the City of New York are going to have to honor your order and do what the statute says, which is to issue summonses or effect arrests and bring before a magistrate. That's the animal cruelty statute. The Department of Health statutes, which are mandatory through the New York City Charter, specifically says that the Department of Health and the City of New York, NYPD, is to shall enforce the health codes.
Is it relevant, notwithstanding that language, as to whether the duty to arrest under a particular statute is ministerial or discretionary? I know you may disagree as to which it is, but does it matter which it is?
I believe it absolutely matters.
Okay,
These
so
are mandatory statutes.
No.
Maybe I'm not following your question, Your Honor.
What I'm asking you is that if a statute says shall, okay, but there's still some discretion within the wording of the statute itself. Here, for example, one of the statutes uses the word justifiable. And again, I understand that you don't think that that is for the police to make that determination.
Yes, ma'am.
But I'm just using it as, if we were to disagree with you, would that make any difference?
The term justifiable?
Yes. I don't want to get into that in answering this question. My question is that if there was an element of discretion in the words of the statute that we agreed was indicated, it says shall, but defined it in such a way that there was some discretion. So you have sort of competing, I guess what I'm suggesting is there's sort of competing messages there.
Is that your interpretation of the animal cruelty statute?
I'm just asking you that's certainly an interpretation that's being argued here.
Correct,
I'm not
yes,
saying that
ma'am.
it's mine, but it is one. And without answering whether it is or is not discretionary, my question is if it were discretionary, would that make a difference?
I think, no. I think when the legislature comes down with a statute or a law or a rule and says that the law enforcement agency, the executive branch, must do this, that's unambiguous. That is clear.
Does it apply if intentionally step on a spider?
No, because there's exceptions in the animal cruelty statute, and that wouldn't be a crime because there'd be no intent if you accidentally stepped on a spider.
Oh, I said intentionally.
Right. Well, there's exceptions in the animal cruelty statute, Section 355A, which sets forth pests, animals that are threats to human safety or
What if
health.
there's a question about whether this particular spider was a threat to my safety or not? What if I'm very, very allergic to spider bites? It could kill me.
Well, then I
So-
guess if somebody called the police, they could ask that a summons be issued to you for doing that. I don't
The
know.
police would be required to issue a summons or arrest me in that instance. That's what I'm asking you.
Your Honor, that's a hypothetical I haven't considered. That's not what the facts are in this
But if we
case.
make a rule here that supports your argument, it will apply to other situations. So we have to be cognizant of that. So I guess what is the rule then? How do we tell the police when there is discretion or there's not discretion in the enforcement of a law that says shall?
Well, in Klosterman, the court just said that in the order. I don't think the court followed up or, checked in. I think that the court
Can I
issued...
get at what I think Judge Stein is asking at a much more convoluted way, which may not help anybody here. When you started this action, it was not started as a mandamus, correct? It was started as a plenary action for an injunction, and Supreme Court converted it to a mandamus?
No, it was started as an action for an injunction and an order to show cause to compel the police, which was mandamus.
Well, but it was converted to a mandamus by Supreme, no?
It was converted to an Article 78.
Article 78, right. So, correct me if I'm wrong, I understood that before the conversion happened, that what you were anticipating was there was going to be an order to show cause for a temporary restraining order of sorts, and then you would have the development of a fuller record. So far, so good, or no?
No, no, the order to show cause, Your Honor, was for an injunction, but also to compel the NYPD to enforce the 15 laws that are violated during this event. And
were
that
you
essentially was...
Were you anticipating the presentation of evidence by both sides, or no?
At that point in the lower court? Mm-hmm. I wasn't anticipating my complaint being stricken, so whatever. I was not anticipating my complaint to be dismissed.
So you were planning to put on evidence and planning to have the city put on evidence and go from there?
Well, no, my original order to show cause, I asked the court to issue an order compelling the NYPD to enforce laws, which was, in effect, requesting a writ of mandamus.
Right.
I just didn't use
And
those
you
words.
don't have, your argument is that the city has no discretion in how to enforce the statute.
No,
I
no,
think
no,
that's
that-
what Judge Stein's getting at.
I see, okay, thank you. I do see what Judge Stein's saying. No, mandamus specifically says, and Klosterman specifically said that you cannot dictate how enforcement will go about, but you can dictate that enforcement will occur. That was the main thing in Klosterman.
But you seem to be equating enforcement with arrests and summonses. And to me, enforcement's broader than that. Enforcement can be, I look at it, and I think I'm not going to do anything here. I'm an enforcement officer. I mean, enforcement isn't only arrests and summons. Enforcement is, I'm going to go out and see.
But that's not what the statute says. That's the difference here. The animal cruelty statute is only one of two statutes that
I think, again, what Judge Stein and I think Judge Wilson are getting at is within, and I think the appellate division did too, within that statute are factors that go to an assessment of what's going on. So in each case, even though there's a must or shall in there, there are factors within the statute that suggest some type of discretion or assessment in the enforcement process.
But does that equal a complete and total abdication and abandonment? Because that's what's happening.
If I can ask, I thought in part, and you correct me here, that you were not only arguing that there's passivity in the sense that they're just that they're not doing anything. I thought you were also arguing that they actually facilitate
Yes, they aid and
the
abet.
breaking of
Yes.
the law.
Yes, ma'am.
Okay, so if that's also what you're arguing, what would then be the order from this court? Because you see the problem that some members of the bench are raising with respect to whether or not the statute, embedded in the statute, you may see it differently, but there may be members of the court, there may be a majority that says, no, there's discretion in this statute. But I thought you were also making a different claim, which is not just, you're not doing what the law mandates, your argument, perhaps people disagree with you, but you're actually facilitating breaking the law, and surely that you cannot do. So stop
Absolutely.
doing that.
Yes, the NYPD is showing up at this event. They're providing police cars, manpower. You've all obviously read my papers, so I don't mean to repeat. Lumbar, generators for this religious event that is not permitted. They don't even apply for a permit. There's establishment clause violations here. Why is this one set getting special treatment? Why do I need a permit for a block party in Queens County? But meanwhile, 60,000 animals are being slaughtered in the street. Just like, all bets are off. I mean, there's something wrong here, Your Honors. I understand that these are complex issues. I understand you have to come up with an order that makes sense and is just, but something has to be done. This cannot continue to spiral out of control, which is what is happening here.
Thank you, Ms. Marino. Counsel?
Your Honor, may it please the court, Lena Drucker on behalf of the city. The remedy that the petitioner is seeking isn't available, both because it's not available in the law enforcement context and because none of the statutes...
Let's say we agreed with you on that point about the enforcement. I know you're going to be able to get back to that and go more expansively. I just don't want to lose the moment on the second point where she says, well, it's not just that you're exercising, or law enforcement is exercising the discretion not to do something, but they're actually doing something that facilitates, furthers the breaking of the law. Would we be able to issue an order responding to that? Let's just assume for one moment it's true. Just assume for that.
Putting aside that I'm not sure there's a concept of aiding and abetting within the constructs of Article 78, I think the greater problem is that the police have an obligation to maintain public order all across the city for unpermitted protests that break up, that come spontaneously.
But isn't that about the merits? She's saying, why are they dismissing my complaint? Why can't I even get to the merits of that?
I mean, I think that isn't the merits, Your Honor. I think that's a question of whether there's ever a remedy available here. And I think the point is the remedy is not available because, as to this aiding and abetting theory, the police have a general obligation to maintain peace. And the petitioner's own papers establish that there's a lot of tension between protesters. There's a large
Wouldn't that go
gathering
to
of
whether or
people.
not, well, using your phrase, you're actually aiding and abetting, which is the merits of whether or not you're doing what she claims, which is you're facilitating breaking of the law without some other societal and law enforcement purpose?
I think that all of the allegations in the complaint are very clearly law enforcement discretionary decisions, providing lights in a potentially tense situation where a large number of people gather, whether it's for a spontaneous Black Lives Matter protest we've had, whether it's for this type of practice. The fact that something is unpermitted doesn't mean that the police aid and abet by making sure that mayhem doesn't ensue.
Am I reading Walsh incorrectly to say that the relief like the requested here is available, but just not through mandamus? And there's an older case from the Court of Appeals called Pumpiansky
Yes.
that sort of suggests the same thing?
I think, if I understand correctly, I think that the line of cases that talk about the availability of mandamus They're all responding, first of all, animated by the sort of acute separation of powers concerns.
I mean, both those cases say mandamus is not the appropriate route.
Exactly. What they say is that mandamus isn't the appropriate remedy, and I think that what Klosterman picks up on is another thread within that, which is that when there's a full abdication of a regulatory scheme, an administrative scheme, a full abdication, which isn't an enforcement decision not to enforce the law in a particular circumstance, but when the executive passes a very detailed, when the legislative branch passes a very detailed scheme and the executive just doesn't take up arms. And then what the courts have been able to do is say, only you must act, we can't tell you how, we can't tell you whether or not to, the mechanics of how it'll be done, but the decision...
What does that mean in this context?
It has no application in this context. What
Your
Klosterman...
position is she has no remedy for whatever it is they're complaining about, because this is all about law enforcement discretion. They have no remedy, recourse in the courts. They may have some political remedy, obviously.
Exactly. No, the remedy, separation of powers concerns are so acute. At their apex in the law enforcement context. If someone doesn't like the discretionary decisions that their executive branch takes, it's our system of government, a bedrock principle, they can vote them out.
So if the police department decided it was never going to prosecute anti-Semitic graffiti in New York City, there's no recourse in the courts?
I think there would be no recourse in the courts, putting aside that the police have to act within the confines of law. So there are potentially recourse with that example, I would think there'd be human rights law violations, potentially constitutional claims about equal protection.
Well, it's the same here as animal cruelty violations. It's the same concept.
Well, I think the difference is that the human rights, the city human rights law potentially would protect.
No, isn't this really what's politically acceptable and possible? Isn't that what you're talking about? And these decisions, not political in the big P, but in a small p, in the allocation of power and who makes the decisions here. And what you're saying to us is that the court can't make this decision, that the administrators and the police department have to make this decision, or their superiors.
Perhaps, yeah, not at the behest of a private citizen. The decision, in this context, what the order from
But there are laws that do require mandatory arrest by police officers, for instance, domestic violence laws.
I think the domestic violence law is a much tougher question.
It is. I agree with you, and it's also the law is more carefully crafted to require that the police act as opposed to this law. But nonetheless, it does exist, and in point of fact, there are laws that do that. So your argument only goes so far.
I think, for the example of the domestic violence law, as is clear, the legislature intended to cabin the discretion of the police officer on the scene. It says not only the police must arrest, but also shall not attempt to reconcile. And there's legislative history behind that.
It seems more like what you're saying is that the exercise of discretion is it's a political, executive, administrative function, not a judicial function.
I think that, yes, as a sort of broad base, that boils down to it, Your Honor. The decision about how to wield this giant law enforcement apparatus, all the different resource allocation issues, potential other threats, other things that go into the picture they require the kind of perspective the executive branch has, not a limited record that the court has at the behest of a private citizen to enforce one law, to reshuffle the decks and reset the priorities of the administration.
But again, as I understand your argument, because her position is, it's not about those things. It's not about deploying resources. It's not about those things. It's about something else, and she wants an opportunity to show something else. And she wants, because there really, in their argument, there is no reason not to enforce these laws. And if it's justifiable, that's for the judiciary to figure out, not the police. But as I understood your argument is, she cannot even go to the court with that argument. She has no judicial recourse, even if she tries to characterize this argument in the way she does. Her recourse is political, and that's it.
That is right, Your Honor. The problem would be if the Department of Health had to reshuffle its deck every time an individual said, I see this as the most important problem facing New York City, 8.5 million people, we have a multitude of threats that are faced both to the police department, to the Department of Health, and they set their priorities based on their expertise, and they have both the institutional competence and the constitutional authority to make those
She
decisions.
stands in the same place, I take it from your argument, as if she was representing a community that says, police never come to our community because of the racial makeup of everyone who lives here.
That, Your Honor, would be an equal protection claim, and one that this court could entertain. It's a very different, there's no...
But my point is, she'd get past the complaint stage because she's got to be able to show that. You're now getting to the merits. That was not my question.
I think the point is that the remedy of mandamus to compel wouldn't be available, but there would be other recourse in the courts, which is what I thought your question was, is whether or not potentially there's the recourse in the courts for people who are dissatisfied. And it depends on the circumstances, but not in this case. None of the agricultural markets law, none of the health codes they've identified, the city charter, nothing is ministerial. So nothing compels a specific action. If it did, then the police would have no discretion.
So if she argued, let me ask you this then. If she argued that the exercise of this discretion is one that shows, and she wants the opportunity to show that, up to you to show otherwise, but she wants the opportunity to show that it's not about deployment of resources. It's about favoring a particular class in a way that perhaps raises some of these other constitutional questions or not. Depends what she claims. Would she then be able to go to court with that kind of an argument?
First of all, that's not her claim. But
Understood.
putting that aside, I believe that mandamus to compel would still not be the available remedy in that circumstance. The limitation of the available remedy of mandamus to compel is about whether or not it's a ministerial function or a ministerial mandatory function, which means that the police officer on the scene has no discretion whatsoever. That means in this case that the police would arrive and they would have no discretion. They would have to arrest 60,000 people, a religious minority, on the eve of their high holiday. They would have no discretion. And if they are acting in an abuse of their discretion in some other manner, that's a different point. If it's not within the confines of the mandamus to compel remedy, this court's jurisprudence goes back pretty much forever saying that the remedy is extraordinary and it's available in extremely rare circumstances. And this is not that circumstance. If Your Honors have no further questions.
Thank you, counsel.
Thank you.
Counsel?
Obviously, I beg to differ with my colleague.
But to be clear, you're not making any of these other arguments that she seems to say there's some carve-outs. There's some places, civil rights, equal protection. You're not making those arguments, just to be clear.
Well, I'm not
And
sure.
your complaint doesn't make those arguments. Your complaints are just
But these are mandatory
yes.
statutes that
And
require
law enforcement is not acting on those statutes.
Yes.
So it has nothing to do with who would be targeted by enforcement, which is the nature of the line of
Well,
question she
the
was getting.
enforcement's supposed to be neutral. This is actually the flip side of the coin from targeting. This is targeting a religious sect and favoring them. This is a violation of the Establishment Clause. Like I said before, I need a permit to throw a block party. I need all these permits. Why is this
Did
particular...
you make those kinds of arguments?
In my papers, yes, ma'am. Yes, ma'am. They're in my papers. And with respect to this resources argument by the city, this is a farce. Saying resource allocation, the resources are there. There's police everywhere during this event, facilitating the event, assisting with the event,
So if they
aiding and abetting the
If
event.
they remove the police, that would also answer your complaint?
No, because the crimes are still being committed. The crimes are being committed, and the public health is being put at risk here. And I know I don't have much time, but this event is growing exponentially every year. When is it going to stop? Where is it going to stop? It started out in one of my plaintiff's affidavits, I think, 5 or 10,000 chickens were used. It was 50 in 2015. It's up to 60 or 70 now. It's spreading into areas of Manhattan and Queens. When is this going to stop? Will it be 500,000 chickens? 1 million? Will
Counsel,
someone have to
if
get
we
sick?
agree with your argument and the police make arrests on the scene, does the prosecuting agency have to go forward with the prosecution of the case?
The statute says, you're talking about the animal cruelty statute. The animal cruelty statute says that a police officer or constable must summons or arrest and bring before a court or magistrate. That's what the statute says.
And then who would prosecute that case?
District Attorney's Office.
And do they have any discretion as to whether or not to go forward or not? Must they prosecute that case?
Your Honor, I don't know what the rules are with District Attorney's Office. I've never been a district attorney, or I don't have an answer to that, Your Honor.
And who would be arrested? Would it be the people in charge? Would it be the rabbis? Would it be the participants? Would it be the children that are taking part in this? I mean, would all of them, would each and every one of them have to be
It would be the
arrested?
people affecting and causing the animal cruelty and the health code violations. So it would be the butchers who are slitting the throats and letting blood drip into the streets and into the sewers and allowing feces to get attached to people's shoes, and people are tracking this into their homes. Your Honors, if you haven't read my plaintiff's affidavits, I beg you to read each and every one of them. It is a horror show out their front doors every year. Where's their right to live in a nuisance-free environment and have their community
The
protected?
question is whether or not mandamus is the appropriate vehicle
Your Honor,
to address those concerns. You've heard her arguments. At the end of the day, her position is that's a political calculation. That's how you have to address it. It's for us to decide whether or not she's right, you're right. But what's your response to that?
Your Honor, if there was ever a case for mandamus, this is the case. And the notion of my clients going to political resources to get some relief here, they have. No one in office wants to touch this. It's a huge group of people. That constitutes a voting bloc, Your Honors. I don't know how else to word this.
Thank you. Ms. Marino, your light's on. Thank you very much.
Thank you, Your Honors.